You ever received a contract and looked at it and said, this doesn't need to be 25 or 30 pages long. It seems like there's a lot of stuff in there we don't need. My name is Andrew Ayers. I'm a business law and estate planning attorney who helps businesses and families protect their legacy through planning. When you get that long contract, a lot of those provisions are going to make you roll your eyes. You say, oh, why is all of this stuff in there? It's what we call boilerplate. In the legal industry, we have a lot of sections that are just in every document that we create. Just because it's boilerplate doesn't mean you shouldn't review it and at least understand what it means. So let's talk about a few of those provisions that are in almost every agreement, and so you know what you need to look at and what you need to worry about. One of the most common ones is headings, and it's usually a provision near the end that just says that the headings are really just used to help guide you through the document. They're not legally enforceable. The next is recitals. Recitals are normally at the front of your document, and think of it really as like a factual background of your situation. It'll usually say who the parties are and why they're entering into that contract. There's often a provision for notices. That will say that if something happens under the contract, if there's a breach of the contract, somebody needs to terminate the contract, or there's some other issue, the notices section says where you have to send the notice. Oftentimes it will have you send it to the other party as well as their attorney, and also with a copy to your attorney. A very important provision you need to look for is the jurisdiction provision. Now, the jurisdiction provision will say where any disputes have to be heard. It will often choose between mediation and litigation, meaning going to a mediator or going to court. It will also tell you that if you have to go to court, where you have to go to court. Are you supposed to go to state court or go to federal court, and what location? So, for example, many contracts that I deal with are based in New York City, and they will specifically say either New York County or Kings County or Queens County, literally taking you down to the local county court level as to where you have to file when there's a dispute. Another clause that's pretty common is waiver, which simply says if you fail to do something, if you fail to give notice, if you fail to object to something, that doesn't mean you're waiving everything under the contract. There's also usually a provision for severability. Now, severability is a way that lawyers use a provision in our contract to try to save it. So the point is, if one portion of your contract is found to be invalid for some reason, there's a lawsuit and the court says we're striking this provision, the rest of the agreement can be held valid. The idea is we're severing the part of the agreement that's unenforceable, but the rest remains in effect. And then there's also usually at the end one for signatures, and this is really the most basic. It'll say whether you have to have original signatures or whether copies and facsimile signatures are sufficient. So when you get that long contract and you look at all this boilerplate language, there may even be a definition section up front. That can be a few pages, literally defining the major terms in your agreement. Don't gloss over all of them. Make sure you take a look at them and understand what you're actually signing. And if you've been given a contract and you'd like to review it with an attorney, you can go to andrewmayers.com and click on the Schedule a Consultation button. That'll take you to my personal calendar where we can set up a free legal strategy session to look at your agreement and see what are the best options for you. I know it can be frustrating that our contracts are so long and with so many of these provisions, but some of them are in there for a reason, and you need to know what that reason is.